We're with John Kelly. John is a personal injury attorney in Phoenix, Arizona, and he's agreed to answer online questions that were posted related to slip and fall cases. With that said, John, let me go into the first question was asked. The first question was from Samantha. Samantha asks, says, I was shopping at the local supermarket when I slipped and fell. The floor was filled with liquid and broken glass from a bottle that someone had knocked over. I had a number of cuts and badly sprained ankle. The store says they didn't know about the spill. Does this mean they're not liable for my injuries?
Samantha has a good question. In these slip and fall cases, there's a lot of factors that go into whether the store is going to have liability. You can't say just because there was something on the floor, they automatically are going to accept liability and will be able to settle the claim right away. We need to make sure that there are other factors that are in favor for us. So one of those things is if there is something as dangerous as a glass on the floor with liquid, it depends on how long the bottle was there, if there was other witnesses that noticed it and reported it, where it was located, if it was in a place that was very difficult for the store to locate and see, it may be harder. But these are things that, have to be investigated. And so what she's going to want to do is get some documentation of that. She's going to want to try to get some photos. If it's already too late and she was transported because she was injured, that's understandable. We may be able to go and look if there's any surveillance video. We may be able to go back and talk to the managers to see if anyone had reported it. Hire an investigator to see if there's any other witnesses at the store that still might be present that we could talk to, and figure out how long that was on the ground. So there's a lot of different factors that play into that type of case. It's a good idea to call an attorney and try to get someone investigating that pretty quickly from the time that it happened.
Okay, next question was from Brian. Brian says, I tripped and fell on a broken walkway leading up to my friend's house. I had just had surgery on my shoulder, which was healing nicely at that point. After the fall on the walkway, I went back to my surgeon and he told me the fall had caused significant nerve damage to my shoulder. Can I get damages for the new shoulder injury, even though it involved a pre-existing condition?
Yeah, Brian can absolutely get damages for his shoulder injury. Even if he had pre-existing injuries, the negligent party is still going to be liable for his injuries that were caused by the accident. So if the area that he tripped was unreasonably dangerous and the owners are held liable for that, which we can try to establish, then they're going to take their victim as they have them. A lot of people have pre-existing injuries, and a lot of people have, just with age, extended injuries on things that they wouldn't have gotten if they were younger. But you can't pick and choose your victim. So Brian is definitely going to have a claim, even though he's actually had surgery on that shoulder. Now there's going to definitely be a heightened scrutiny of his case, and the insurance company is going to probably request all his past records to see if they can see if some of that damage to the shoulder was already there. But that's part of the attorney's job, is to make sure that the client's getting the right treatment, the right evaluations, and knows what to expect moving forward in a claim like this. But he does have a claim.
Okay, excellent. Next question was from Charles. Charles said, I fell on the sidewalk and suffered an injury. The insurance company keeps telling me to hold on because they're about to offer me a settlement. They also said there's no need for me to get a lawyer since they're going to take care of me with a fair settlement. It's been almost 2 years since the fall. Should I be concerned?
Yes, absolutely you should be concerned, because if 2 years passes, his claim could be gone for good. The statute of limitations in Arizona, typically on a slip and fall case, there are some exceptions, is going to be 2 years. Sometimes it can be 1 year, so you need to reach out to an attorney right away when you find out. But if it's been 2 years since the accident and he still hasn't had an offer, I have very little faith that the insurance company at that point is going to come forth with a fair offer. In fact, I would imagine that they're just sitting there waiting for the 2 years to run and hoping that no claim is made. he's going to need to file a lawsuit. So he's going to want to talk to an attorney. That attorney is going to have to get on board, investigate, and get that lawsuit filed quickly. And so that's an important thing for him to do. I don't trust the insurance companies to make a fair offer. They usually don't.
Okay, next question was from Lucy. I fell on the floor in at the supermarket and was injured. The floor had just been waxed and was very slippery, but witnesses saw that I was just about running down the aisle when I fell. If I'm partially at fault, can I still get damages for the injuries?
Lucy can still get damages even though she was running, but it sounds like a pretty difficult case, because if you're comparatively at fault for the accident, your claim starts to diminish based on that. And running down an aisle is something that is not the norm. It's not a safe thing to do. There could be some circumstances that it could be argued that it was necessary, but I think that it's going to be a problem that she's going to need to make sure that she does everything she can to overcome. So if there were some other circumstances that were making her run, or if the floor was just so unreasonably dangerous that even if she had been walking, she would have been injured, she still does have a claim. So just needs to be evaluated. Hopefully it's documented, with photographs and that kind of thing. So she could call an attorney, talk it over with them, see if she can get a lawyer that would be able to pursue it and make a claim for it.
Okay, and the final question we had was from Frank. Frank says, after I was injured in a slip and fall accident in a retail store, I received medical treatment. I know how much my bills are. I know how much I lost from being out of work. Can't I just use like an online calculator to figure out how much my case is worth? Why would I need a personal injury lawyer in this situation?
Well, Frank does not need a personal injury lawyer. He can try to settle the claim on his own. And if he wants to use an online calculator, I have no problem with him attempting to evaluate his claim that way. I can say that it is difficult to get the insurance companies to make a fair offer in slip and fall cases without working them up. So if he does have that ability to get that done quickly without, starting to get close to statute of limitations issues and potentially harming his claim that way, I would encourage him to do it and try to settle it. If they make a fair offer, there's no reason he needs an attorney. Now, if his injuries are pretty severe and he has a lot of medical expenses, it is probably a good idea, because he's going to have to work with liens from the hospitals and any other medical care providers. So even if he does get a settlement offer, he's going to have to figure out how to resolve all those liens to make sure they're not coming back and requiring him to pay more than he should be. So there are some issues that can come up. Not always needed, an attorney isn't, but it's always easy to just pick up the phone and call a lawyer and ask for their opinion, because most personal injury attorneys are happy, including myself, to do a free consultation. If you like what you hear, you can come in, you can sign up with a fee agreement. Otherwise, you can say, you know what, I want to try this on my own. So it's up to the client. Okay, excellent. If you have any other questions for John, just post them in the comments section below, and he's agreed to get back with answers. Thanks, John. Thank you, Ryan. I can be reached at 602-283-4122 at my office, Kelly Law Team. Thanks.